Welcome, Consumer Law 101 viewers. My name is Mike Adada. I'm the CTO of Swift Law North. Joining us today is Aaron Swift, who's our CEO. How are you, Aaron?
Good, Mike. Thank you.
All right, today's lecture video is the sixth in the FCRA 101 series and is titled Suing CRAs under the FCRA, Secrets of 1681EB and 1681I. So, Aaron, where do we begin with this topic?
Like we did for the fifth video, which is secrets to suing the furnishers, and now we're on the secrets to suing the CRAs, I want to start again, just set the stage for it. Let's talk what this even means. So in this particular case, because we're suing a furnisher, the consumer has identified an error, whether it's inaccuracy, something that's incomplete, material misleading, which we'll learn about a little bit later today or whenever you watch that video. There's a problem. And whether that's a problem that required disputing or not, the consumer is ready to sue. Everything's been ripened. So that's where we're at. And the question is, well, what are we suing these credit reporting agencies for? And, oh, hi, Penny. Hi, Bubba's. Again, mascot Penny may come in and out of videos. Don't worry about it. So when we're talking about we have a problem, we're going to sue on behalf of the consumer against the credit reporting agency, there are two types of potential claims.
Okay.
That's different than video 5. Again, we just watched, which you can only sue a furnisher under 1681 S2B. You can sue a credit reporting agencies under two separate subsections,
yes.
1681I and 1681EB.
Okay, thank you. And now with that understanding, what else do our viewers need to know about the secrets of suing CRAs?
Okay, so let's really talk about those two things in more detail because that's kind of the secret. So if you're going to sue a CRA under EB,
okay,
that means you are suing the reporting agency for, quote, failing to follow reasonable procedures
okay,
to assure the maximum possible accuracy of a credit report. And that, well, hold on, Mike, just 1 second. That's one way.
Yes.
You can also sue a credit reporting agency for failing to perform a reasonable investigation after they've been put on notice of a dispute. So those are the two ways you can sue a credit reporting agency. One way to sue a furnisher under S2B, you must dispute first. Two ways to sue a credit reporting agency. EB does not require a dispute, just requires maximum possible accuracy. And 1681I does require a dispute, but then you're suing because a reasonable investigation was not performed.
Okay, and what do you mean by maximum possible accuracy?
It's kind of built into the word, right? So it's maximum possible accuracy, which is a high bar, right?
Yeah.
So, and the really crux, as us legal lawyers like to argue over, legal lawyers is a little redundant, but it's the word possible and that phrase that matters. So again, in context, we're talking about billions of bits of information exchanged every day, lots of disputes, but they have to follow reasonable procedures to assure the maximum possible accuracy. And so in practice, in cases, it's basically, did they use reasonable, decision-making? Did they consider all relevant evidence? Did they not do this in a vacuum? There's no specific answer as to what it means to be the maximum possible accuracy. But again, it's such a high bar, and we always really impress upon that with our consumers, our partners, and ultimately in cases because it's such a high bar.
Okay, and what did you mean by reasonable investigation?
So again, we're talking about the second path by which a consumer can sue a credit reporting agency, and that's under 1681I. Maximum possible accuracy is 1681EB. 1681I is we're saying a reasonable investigation wasn't performed. So what case law suggests, and courts, when they break down what does that mean, it's you can't perform these investigations in a vacuum. So I'll just give you one example. Let's say a consumer disputes to Experian, again, not picking on Experian, just as a hypothetical, to say, I didn't pay this debt late, here's my proof, see attached. They're supposed to perform a reasonable investigation. Well, you're going to learn a little bit later some of the secrets of this industry, what that actually means behind the scenes. And the question is that reasonable? So if the credit reporting agency didn't look at all the information that consumers supplied, well, that's not going to be reasonable. If they responded late. If it took longer than 30 days, that's not going to be reasonable. If it's so obvious on the face of something and then they just believe that, the creditor or the furnisher, and that happens a lot. Consumer disputes information seems so objective and clear, but as part of the investigation, the CRA goes to the furnisher just spits back a verification and says, no, we're right, and it kind of all falls apart. That's why the standard is you still have to perform a reasonable investigation. So what if that consumer has disputed the thing 3 times? Is it reasonable to not look back at the last 2 investigations? I would say no, but most cases that doesn't happen. Is it reasonable that same dispute issue could be handled by 3 different dispute operators who have no ability to talk to each other, who don't even know what the last one did? So you just kind of take it into context, the totality of the circumstances to say what information's given, what do the CRAs have access to, and then that standard's kind of left up to the jury, but it still has to be reasonable.
Okay. And lastly, can you tell us how all this connects to the larger picture of credit repair?
Suing credit reporting agencies is often the last and only resort that consumers have. And to put that into context, consumers find credit repair professionals, insiders, they find do-it-yourself tools or self-help books online. But what happens when efforts, even efforts that should work, on objective errors, if they don't work? That's when litigation comes in. It's the last road, often, as it should be, but that's an opportunity to finally fix the problem. Credit repair has its uses, of course, and disputes that work should work, if they're factually based and legally informed. But if it doesn't work, then what? That's when litigation comes in, because litigation can A, fix the problem always, that's the goal, but B and C, get compensation for the consumer and allow them to get representation by attorneys on a contingency fee basis. So if the efforts pre-litigation don't work, litigation can work. And even if it does, because we've had cases like this where dispute number 7 finally works, we're still going to sue because disputes 1 through 6 prove that there weren't reasonable investigations.
Okay.
Or that there wasn't maximum possible accuracy. And what are they going to say? Well, if you fixed it on dispute 7, the information before could not have been the maximum possible accuracy. It's more accurate now.
Right.
Or then how were the first 6 investigations reasonable if it took the 7th to finally fix it? So again, just to tie this in a bow, the best credit repair, the gold standard of credit repair, has to be legally informed and based on facts. And if that doesn't work, to have the backbone, to be supported by lawyers who are willing to fight these companies, to take what doesn't work in credit repair, the next step, to use litigation as that tool, to finally get the fixes. But on top of that, compensation for the consumers and more money for the affiliates, because again, the defendants in these cases, the ones that break the law, ultimately have to pay.
Okay, great. Thank you, Aaron. As always, if you guys have any further questions, you can let us know in the weekly sessions or in the group chats.
Thank you.